listening to Legacy Lawyers, hosted by Michael Haslam and Nathan Croxford.
Hey, everybody. This is Nathan. Normally, when you turn on this podcast, you get me and my law partner, Michael Haslam, but he is busy doing some other things today, and we have a new partner to introduce to you. So with me today is a litigation attorney that's been with us for, I don't know, how long have you been with us now, Tyler?
I think I started helping cases back in 2019, but I was with, different firm at the time and now officially joined up.
Cool.
Just recently. So
this is Tyler Moss, everyone, and he handles, it's crazy, just the number of estate planning clients that we've built over the years that that Boynton Legal's been a law firm. Over time, people call in and they have various things come up and disputes. And so we needed somebody good to help us handle those cases because as planners, we spend all of our time planning. We don't litigate. I started out my career as a litigator, and within 5 years, I was like, yeah, I'm out. Life's too short to litigate. But Tyler seems to think otherwise. I don't know how you do it. The other crazy thing about him is that he's like a super nice guy. And so to get like a really effective litigator in the same body as a really nice guy, that's super rare. Like, I don't know. I couldn't count on one hand the number of litigators that I can stand to be in the room with for very long. But Tyler is one of those guys that I definitely could hang out with. So,
well, that's sure.
Welcome, Tyler. And today we're going to talk about something that is going to affect a lot of our business owner clients, anybody that's currently in business or considering starting a business. And the specific issue we're going to tackle today is non-compete agreements. So just to give you a background for some of you that might not be familiar with those, when you start a business, you usually are building intellectual property, so information that's confidential. You're building a client base, you're building a team. And if somebody leaves your operation to go work for someone else, what you can't have happening is them taking confidential information with them, using it. You can't have them trying to recruit your clients, your customers, and you definitely don't want them trying to pick off people that work for you to come work with them. So all of those issues are brought up in various types of agreements. Specifically, though, the non-compete part is using confidential information or access to client lists and so forth to go out and compete, or just opening a similar business and trying to compete directly for the same type of clients that the person was helping before they left their employment. Did I cover that all right?
Yeah, I think that's a really good, definition of what a non-compete would be and is, that protects the business interests of corporate clients. And in addition to non-competes, there can also be, non-solicitations that go a little bit further just for solicitations. Or I always like to use, like Coca-Cola. They've got that secret sauce that everybody just loves to drink, and whether it's diet or Coke Zero or whatever your favorite drink may be. But, if everybody knew that recipe, it probably wouldn't be wouldn't be that secret sauce that makes Coca-Cola so famous. So it's these sort of documents, legal and binding documents that we draft, and we try to protect those companies with their confidential information, their trade secrets. And there are other laws in addition to, these restrictive covenants like non-solicitations, non-competes, or confidentiality agreements that can protect the companies. And that's, a sample of that would be like the Utah Uniform Trade Secrets Act. It protects your trade secrets. So there's several items that can protect the company, one of them, chief among them, being the non-competes.
Okay. So traditionally, I mean, non-competes have been used for a very, very long time. It's not just corporate employees. I mean, this could go down to a small mom and pop operation that doesn't want somebody moving further down Main Street and opening the same burger joint, opening a competing burger joint. So one of the things that they can do is have their employees, as a condition of their employment, sign a non-compete agreement that says, I agree that for a certain period of time and within a certain geographic area, usually, that I will not, if I leave the company, this is binding even after they leave their employment, I will not compete with my former employer. Now, are those, I mean, what I know about non-compete agreements is that they're disfavored by the court. So they're binding and the courts will uphold them, but there's certain things that the courts will uphold that they're considered disfavored right out of the gate. So what that means, I think, is that you have to be careful that you draft it in such a way that a court will actually recognize it. So why are they disfavored?
Yeah, that's a great question. And, a lot of people wonder that when, why am I getting into one? Why do I have to sign one? Why is my employer, maybe requiring me to do this as part of a condition of my employment? And so the courts, they don't, well, backing up even further, I mean, it kind of goes a little bit to constitutional rights of going back to even, slavery. And there is some case law on that particular point where we don't want to be, enslaving anyone to work for anyone, but there's this business interest that courts recognize. And so they're disfavored, generally speaking, just because they want to give you and I the right to go and work in the free market. And so the courts do place certain, conditions on those restrictive covenants, and they are strictly construed. So it is a challenge that a lot of employers have to go enforce those non-competes. Yeah, and there's several elements that they've got to meet.
Okay. Yeah, and I mean, I think you've said this, but just to be really clear, I think one of the other reasons they're disfavored is that we don't want somebody to work for a company, for an employer, have a bad experience, or for whatever reason leave, and then not be able to provide for their family or for themselves because we put such a big restriction on them that they either have to completely change what they're doing. I mean, if the non-compete's broad enough, I think there's probably scenarios where you could, where it's been attempted to say you can't work anywhere in the United States competing against us. And maybe there's a type of business that would pass muster. I think that'd be a tough sell. The other thing is they don't want the time restriction to be so onerous that somebody basically has to go and change what they do for a living or completely move out of the state, out of the city, in order to be able to continue to do what they do. So kind of the idea that a non-compete should not force someone to change their line of work just because they, agreed to sign this thing. I'll tell you a story that I have with this is a gentleman that lives in my neighborhood. He worked for a flooring company and had signed a non-compete. He was a sales guy and he had signed a non-compete with them saying that if he ever left, he would not, work for somebody else and compete in northern Utah. So, and he never tried to challenge it. And I think that's largely how this goes. I think these are effective, even though they're disfavored, because just the simple fact of having one gives people pause. I can't tell you how many times I've had clients over the years say, can you look at this non-compete and tell me what I can and can't do? And for the most part, they're not going to spend the money to lawyer up and challenge it, or they're not going to go violate it in hopes that they don't get sued. So in this particular case, this gentleman had to move to St. George for, I think, a 2-year period until the non-compete was up. so he could work for a different company in flooring and still be able to, ply his trade. And in this particular instance, this caused major anxiety and depression. It was a big deal. They had to leave their family up here to go down there to work. And it was, when you talk to him, it was like one of the most traumatic experiences of his life that he had to leave to be able to work. And as soon as it was up, he was back up here and working for another company. So they're powerful. I've seen them they're definitely powerful in terms of keeping people from competing. Maybe you have some experience with them also being powerful in terms of protecting on the corporate side.
Yeah, and I think your story was a great one that I think a lot of people can relate to. And I think I was just going to make the point that you raised a good issue where it was a salesman, right, in your story. And non-competes, because sales folks there's a lot of times they're the heart and blood of a company when you're for generating income. Those are the non-competes that employers really want to be careful how they draft those to protect their rights in the market. And so the other people are kind of higher up, or executives. A lot of times they'll have a non-compete, sometimes because they're so high up. However, they'll try to negotiate out of the non-compete. And so I remember in my practice early on, where we had multiple trials on non-competes, and we represented a really good Utah, I'll just use it, kind of a behavioral health and therapy company.
Okay.
And they had multiple therapists that were leading. They were kind of like executives or vice presidents of a particular location. And I think that their non-compete said the entire city of Utah, you just can't compete there. And there were a few employees that we had trouble enforcing that with the court because it was too broad of a scope, right? And this one employee only worked, I think, up in Logan, and that was the only place that employee had worked and didn't travel throughout the state of Utah. And so in that particular case, I think we negotiated a settlement, right, to, instead of going to court and incurring all those costs, we voluntarily narrowed that scope of
the geographic scope.
Yeah.
So do you remember what it got narrowed to?
I think it was just within like a 20 or 30 mile radius
of Logan.
Okay. Yeah.
So basically Cache Valley.
Yeah. Like Cache Valley. So the family could still move out 20, 30 miles away and still have that work, ability to work and have a good job.
They could have moved into the Ogden metropolitan area. They could have moved into Davis County. They could have moved to Salt Lake. They could have gone.
Yeah.
It wouldn't have been it's still a hardship, but not probably an undue hardship to have to move city in the same state. Exactly.
Yeah. And then on the other hand, we had another executive who was traveling to all the different offices throughout the whole state. And this was a female-owned company. They were doing they were booming. Their company was doing fantastic. So they were opening offices left and right all throughout the state. And there was one particular executive who really was a starter, founder kind of all those different offices.
Mm-hmm.
And so in that instance, because he really had his footprint all over the state of Utah, we actually could enforce that provision to say he can't compete in the whole state of Utah. So it depends.
That's super interesting, right? Because so that was kind of based on, and this is probably, like you said, they're strictly construed. The court's going to look very carefully at the facts of each case.
Yep.
When they're applying the law, and they're going to look at, is that geographic restriction reasonable? And in a scenario where a salesman has relationships all over the state, the company's probably not going to get the protection that they bargained for under the agreement if they don't have a statewide, protection against competition. That person really couldn't go do what they do without running into those same people and essentially competing with those, clients or whoever they're working with.
Right. And this was back, I think that that particular non-compete was, I think, either a 2 or 3 year non-compete. And we were able to cite to older Utah case law and 10th Circuit case law that, had enforced historically non-competes up to like 5 years.
Wow.
And I think even beyond that. So the law has since changed.
I was going to say, so what's kind of the norm? And then we're going to get to the point of our podcast is to talk about an FTC, Federal Trade Commission ruling that sought to ban non-competes altogether, and a lawsuit that was brought to challenge that rule. But because my experience, I'll just tell you as a non-litigator, kind of what I've told people, and maybe you can tell me if I've been committing malpractice by advising them this way, and this would be a good time. We need to get our, what's the word I'm looking for? I don't remember what I'm calling it, but normally what we'll do is put out a statement at the beginning of the podcast that says, we're both lawyers. You practice in the area where you deal specifically with non-competes. I have prepared non-competes, but the purpose of our podcast today is not to provide legal advice. This is for educational and obviously entertainment purposes. So find yourself in a scenario where you're looking at a non-compete, you're listening to this podcast. Please seek out a qualified attorney to advise you on your specific circumstances. So anyway, with that, what have you seen? Because what I've told people is courts will typically not countenance a non-compete that's longer than a year. And I'm not as clear on the geographic area. I realize that does have some teeth depending on the facts of the case. But tell me some of your experience as far as non-competes, time frames, the time restrictions, and the geographic restrictions that have held.
Yeah, so you're correct. You have not been committing malpractice.
Okay, good. Good.
Yeah, at least here in Utah, it's a 1 year, right?
Okay.
So the non-competes, there was the Utah State Legislature changed the rule. I think it was back in 2018. I want to say it could have been 2016, but it's been in place now for a while. So employers, if they're going to be doing non-competes, generally it's the 1 year. As far as the geographical location, it is very fact sensitive to that particular employee. It's also has to do with the line of business. And, there's been cases like if you own an ice cream shop, right? And let's say you're the guy or gal who is, putting in the different flavors of the huckleberry, flavor or whatever is your favorite. I like Superman ice cream, which is all the colored flavored ice cream, bright.
I've never heard of it.
And some people are like, that's the nastiest stuff on the planet, but I really like it. And so I'll have to get you some, Nathan.
I'm a pralines and cream type guy.
Oh, okay. Well,
or
Christmas is coming up.
Or something chocolate.
Yeah. My wife loves the chocolate kind.
Yeah.
And so, if you're that sort of an employee that's making the actual kind of trade secret, if you will, then the geographical location can be broader.
Meaning if you're in possession of the recipe, the recipe.
Yeah, that's right.
So,
yep.
So to give some of our younger viewers or some of our viewers that are more mature but happen to be a fan of the SpongeBob franchise.
Right.
SpongeBob could have a larger geographic location on Krabby Patties because he has the secret formula that Plankton's always trying to get from Mr. Krabs, right?
That's exactly right. Yeah.
So because he's actually putting the ingredients in and mixing it up and then putting those things on and cooking them to perfection. So SpongeBob would be in Utah. He'd potentially not be able to work in the state of Utah.
That's right. Yeah. Okay. Whereas, the delivery person of the patties or of the ice cream, their geographical location's probably going to be much narrower because just the fact of mere delivery isn't related to the protecting the business interests of that, trade secret.
Or even to continue our analogy, Squidward at the cashier at the front who doesn't know the secret formula
That's right.
His is going to be much more narrow. He could go court.
Okay.
He could go cashier probably at other burger joints and
Yes.
not
Yep.
be hurting the company.
That's exactly
All
right.
right.
Yep.
Okay.
Yep.
My kids will be thrilled that I found a way to get SpongeBob into one of our podcasts. I'm actually quite proud of it myself, to be.
Yeah, that was
completely
amazing.
honest. So then tell me, what was the ruling and what happened as a result of the ruling? So the FTC, the Federal Trade Commission, I don't know the reason, but at some point they came out and said, we're going to issue a new rule that bans non-competes.
Yeah. So you mentioned earlier that, I'm a litigator and you don't know how I do that. That might be part of my DNA defect, but my other DNA defect might be that I like politics, right? Law and politics.
Okay.
But with the current administration, very union friendly. And so they,
So to be clear, 2024, we're talking the Biden administration.
The Biden administration,
Okay.
yes.
Biden
correct.
administration, pro-labor, pro-union.
Yep.
So what's the interest of that? What's their interest in not having non-competes?
Yeah. So there's the National Labor and Relations Act that is aimed, to protect unions and to protect employees. And part of that, there's a provision in there that says that the aim of that act is to prevent unfair competition. Okay.
Okay.
And so early, I think it was even before this Ryan decision, the Biden administration had put more teeth into the NLRB and that particular act. And so when if you had a union employee, and I was in-house counsel for a company where in California we had a very strong union presence. And so they were making a very strong point that in these employee contracts, and even like severance agreements, those sort of contracts, they found it to be in violation of the NLRB Act if you had certain language relating to non-competes. And there were, exceptions, and there was, language that would be permissible. But I think it was on those coattails that this FTC went even further and said, okay, we're going to make a ban throughout the whole United States. And there's a few exceptions as well, but by and large, it was a ban on non-compete. So altogether, employers could not have non-competes.
So this would be like the FTC director that was appointed by the Biden administration. So this is someone that shares their political views on labor and protecting people's rights to work. So, okay, so they issue a rule back in, I don't know, I think it was like April or something. I could have that wrong, but it was supposed to go into effect on September 4th of 2024. So just a couple of months ago. But a company by the name of Ryan LLC brought a lawsuit. Tell us a little bit about that lawsuit. Well, let's say, first of all, we looked this up before we got on today. I'm actually on the Ryan website. They're like a national firm that provides tax related software and consulting and so forth. So they probably have a very large national presence. Says that they work with issues for many of the global 5,000 corporations. So they deal with a lot of big companies in terms of their taxes and tax software, right?
That's right. So you can imagine just how many of their clients, had an interest in what Ryan LLC was pursuing. The court made an interest.
I got to break in. It's even bigger than that.
Yeah.
Multidisciplinary team of more than 4,800 professionals and associates serve over 30,000 clients in more than 80 countries. So they're huge.
Yeah, they're a big, huge company.
Big
and
player.
yeah, and the court in this case they made an interesting statistic that said commission estimates that approximately 1 in 5 American workers, or approximately 30 million workers, is subject to a non-compete.
Wow.
So that just gives you the scope of how many people we're talking about that would have been affected by the ruling by the new FTC rule on banning.
So this probably sent shockwaves through the business community, widespread panic amongst corporations like this, that they're like, well, if they ban non-competes, we're gonna have people leaving left and right, and they're gonna go join our competitors, or they're gonna start competing businesses, and they're gonna cut into, our market share.
Yeah, and being a tax company and providing tax services with, high executives, and you can imagine just how many phone calls Ryan LLC alone received, just saying, hey, what's going to be my tax consequence if I can't, have these non-competes with any of my employees?
Yeah, that's true too.
So, and, so Ryan LLC ultimately made the decision that they would bring an action to enjoin this rule, and ultimately prevailed. But there's a lot of, legal analysis that goes into this. And, what do you think about the kind of just that analysis of the case?
Well, I'll be honest, I didn't read it super carefully. I'm relying on you for that part of it. And I'm sure you read it. You poured over this for hours, right?
Right.
Just to give a little bit more background. So they brought a lawsuit in the Northern District of Texas, Dallas Division. So a federal court in Dallas, Texas. And what was the basis of their challenge?
Yeah, so they were basically saying that the FTC did not have the authority to upend all of these, 30 million non-competes.
Okay, so they challenged the FTC's rulemaking authority.
Right.
To say this is something that Congress could do, for example, elected officials, but you, as just a federal agency, you lack the power to enact that kind of a rule and make it applicable nationwide. Is that fair?
That is fair, yeah. And
Okay.
there still may be some legislation from Congress that comes from this. We don't know yet, but there hasn't been anything that I'm aware of that's come about after this. I know that this case I think it's on appeal to the Fifth Circuit, so it may eventually reach the United States Supreme Court. We'll just have to keep watching.
Yeah, cool. And if that happens, like we'll swing back and do a check-in on this on a later podcast. But So they challenged the rulemaking authority, and then what was the result? What was the outcome of that case?
So the outcome was that the FTC ban on non-competes was enjoined, so meaning it's not in effect, and that all the employers, their non-competes at least would not be deemed invalid or unenforceable pursuant to this new FTC rule.
So the rule did not go into effect on September 4th. They essentially stayed the effective date of that ruling and said, this won't be happening.
That's correct. Yeah.
So it's a pause. It's not completely dead. It might not be dead at all. It might, on appeal, the Fifth Circuit might disagree, although there is a recent Supreme Court case that you and I talked about a little bit before we got on today, the Loper case, and we're probably getting a little bit into the weeds. Stick with us. If we are, we'll circle back to the applicability here in a minute. But basically where the Supreme Court so Chevron powers was basically, and deference was basically saying that when a federal agency makes a rule, the courts are going to give deference to the federal agency because it's within their purview to make those kinds of rules. So that was all through law school. I remember reading that case, the Chevron case, and the Chevron doctrine. But that is dead. As of this year, the Supreme Court killed that and said Chevron is overruled. So that's no longer good law. And so it'd be interesting to see how the Fifth Circuit's going to get around the Northern District of Texas's ruling, given that it does cite that case. So that'll be interesting.
Yeah, I think you're right. I think that will be really interesting. And I think the Fifth Circuit's going to have a hard time to, overturn the Texas District Court decision because of that Loper decision. I mean, that's a United States Supreme Court decision where the Fifth Circuit, is underneath that jurisdiction. So, and the Loper decision basically said if there's a federal statute that were to go into place, or there was a statute and their federal agency was interpreting that statute, historically under Chevron stood for the proposition that the federal agency's interpretation of that statute would be enforced as long as it was a reasonable interpretation.
Okay.
Which who's to know, if there's two different interpretations. The courts historically just said, hey, that's a federal agency decision, so we're going to let them govern themselves. Now it's shifted, where under the Loper, the new Supreme Court decision has said, well, actually, if you're going to be interpreting law, that final interpretation shouldn't be with maybe executive type appointees in that federal agency, but it should be within a trained lawyer judge who is appointed by the president and confirmed by the Senate. And so now actually the courts can still look to the agency's interpretation, but it's the courts who are going to be giving a final determination on those statutes in question. So for
it's
example,
interesting. Sorry.
So how it kind of dovetails into this is if the FTC were to go back again and say, okay, well, our 1 year or our complete ban was invalidated. Let's say that goes all the way up to the Supreme Court and it's affirmed. They come back again and they make another rule or try to get another statute regarding non-competes.
Or take a different interpretation.
Yeah. Give a different interpretation, different spin on that. I'm thinking that the new jurisprudence under the Loper decision by the United States Supreme Court would say, well, that's going to have to be challenged in the courts, and the courts are going to have to rule on that as a matter of law.
What would also be interesting, going further into the weeds, is if Congress, let's say Congress had enacted this rule, then the Loper case has nothing to do with a challenge to the actual statute that Congress enacts saying all non-competes are banned. So at that point, that would probably be challenged as well, but that challenge is going to have a completely different legal basis, probably something to do with, the Commerce Clause or something, a constitutional based challenge. So
yeah,
that would be super interesting too.
That would be.
I think it'd be harder to get Congress though to come to terms on such a sweeping rule, right? That essentially bans non-competes across the board, except in very narrow circumstances. So,
yep.
So as far as the applicability of all of this for people that are listening, can you just give us kind of just sum it up? What does this mean going forward for businesses, for our business client listeners?
Yeah, you bet. I think in summation, if you have a company.
That's such a litigator thing to say. In summation, Your Honor. You can tell Tyler spends time in court.
And Nathan, you're the judge right now.
I can't remember the last time that I actually said out loud in summation.
Or how about may it please the court?
Yeah, no, I haven't said that either. Not for a long, long time.
Yeah.
Nor do I have any plans to go back and do much of that ever again. So,
I got your back.
In
there.
summation, counsel.
Yeah, in summation, here we go again.
Okay.
No, but just in short, employers, if you have a non-compete, we're happy to help provide some advice there. But the FTC rule that attempted to eliminate your non-competes, you can have that sigh of relief with those non-competes. Generally, as a matter of generality, they should still be good. If you have any question at all, we're happy to talk with you, and even, for future employees, we can work with you to draft them if we need to have them, more narrowly tailored to your interests. And so as of right now, that FTC ban is not in effect.
So it's basically status quo, like it's been for years and years and years.
That's right.
Non-competes are in place. Our non-competes are still binding, but they're still a disfavored type of agreement. They're going to be subject to strict scrutiny. The court is going to be very careful at looking at the individual facts of the case to determine whether or not the time restriction and the geographic restriction is reasonable and narrowly tailored to protect the company without hurting the employee. So all those things are still in place until further notice.
Yep. I think that's a perfect summation.
Okay. Well, there you go. The non-litigating attorney gave a perfect summation according to the litigating attorney. So, hey, Tyler, great to have you on our podcast. I appreciate you bringing your expertise to the table today, and hopefully our listeners learn something and they can not be panicking that as a matter of, that across the board, non-competes are no good anymore. Non-competes are still good. You just have to be careful with them.
That's right. Yep.
All right. Anything else before we sign off until next time?
No, I think, America is a great place to live, and we've got great companies, and,
I agree.
There's non-competes serve a good purpose. And so, like I said at the earlier outset of the podcast, there's, non-competes, there's non-solicitations. We really didn't talk much about that, but non-solicitations, the courts do give a little bit more deference to non-solicitations because it doesn't completely just ban that person from working. What a non-solicitation does is it just says, hey, you can't target, the employer's customer list.
Yeah, that's more narrowly tailored to protect the company on a specific issue, right?
Yeah.
Not losing, not having their clients picked off, not having their team members, their staff picked off. And then you also see non-disclosure agreements folded in with non-competes and non-solicitation. So it might be that you have an agreement out there that has all three of those components, but this particular rule was only aimed at the non-compete portion. So
that's right.
But generally speaking, non-competes are business as usual. All right. Well, thanks everybody. Thanks for joining us, and we will catch you on the next one. See ya.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Boynton Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.